All rise. 14A District Court for County of Washington, State of Michigan is now back in session. The Honorable Judge J. W. Simpson presiding.
You may be seated. On Monica King versus Sarah Goebel. Your name, ma'am?
Sorry, sir. It is Sarah Goebel.
All right. And where are we on this case?
I know the court's familiar with both the situation and the case because you dismissed a prior case in terms of the non-payment claim. The rent now due is $4,800. The costs are $258 for a total of $5,058. But we amended our complaint to include a termination of tenancy case, and in neither circumstance is there a triable issue.
So yesterday I did apply for our DHS assistance, so I can at least try to get some. I do not owe all of that, Your Honor. I did say that last time. I'm going to say that again. All of this started over her assaulting me and me calling the police. This is the whole reason why this situation started. I am looking to move, and I am going to move. I just kind of want to make sure that all of this is taken care of. I don't feel safe living in her home anymore. She's now, since started, she's now shut off the Wi-Fi, which was supposed to be included in the rent. She is shut off. She shut the fuse off downstairs to the washer and dryer, so I no longer come to the washer and dryer. She has taken the lock off the spring door, so I can no longer lock the spring door.
Judge, are we trying this case now?
I don't know what we're doing. Ma'am, but you want to move out?
I do want to look to move out, so I am asking that DHS help me get this paid, so that way I don't owe any money.
Well, this is a possession only case. They're not asking for a money judgment at this time.
I thought that.
So it's just a possession only case. So when are you going to move?
By July 1st. Really, probably.
The 10 days would be the 28th. I think the first, I think it's a Monday. Is that right?
First is a Monday.
So if we have a judgment with no redemption amount for the 28th and she's gone by the 1st, she will have satisfied the judgment.
What?
I have no idea what any of that means. Sorry.
Basically, there would be a judgment. There's nothing in this case for me to try. Okay. So first of all, so there would be a judgment. You want to move.
Yes.
They're not asking at this time for money. So it would just be fashioning a judgment for a move out date. And you would normally get 10 days. Okay. You said July 1st, you would normally get 10 days. I would make it the 28th, which would be 10 days, but that's a Friday. And so the 1st is that Monday.
Okay. Sounds good to me.
Does it work?
Yeah.
Okay. Court,
Your Honor, I have
after hearing no tribal issue.
And I'll take out the redemption amount.
Correct. There'll be no redemption amount. We'll just do it as a termination. You'll move. That sound good?
Yes, sir. Thank you.
All right.
She doesn't. Then I had to come in.
Well, hold on. Well, hold on.
Oh,
We're not quite done. Okay. So, ma'am, the judgment here in front of me, they're not going to put a redemption date. So basically it just means you're going to move and that you're going to move by June 28th, 2024, which would be your 10 days. And I'm finding that based after a hearing on no tribal issue. Any questions you have?
So what with them saying that I owe this money though, what is that really?
They would have to bring another claim if they're claiming that you owe money.
Okay.
But that's not right now. That's not before me.
Okay. And then the other question would be, with this being an eviction, is this an eviction so that it'll go on my record? Is that correct?
It would. It would. I hate when people say it, their record, but what will happen is that it will show that there was a judgment entered for possession.
My question is, with her stating that there's all these other people in the home, is it going to go, because that's my mother-in-law, my brother-in-law that don't live there, none of them live there, my husband, is that going to go on them too as well? Well,
the people that I have in the case are Sarah and Donald Goebel, and Joshua Goebel.
Yeah.
And Gladys Down.
Yeah, and that's what I don't understand is why she has all these people that live in my home.
Are they in the premises?
No, sir. They were my guests here and there. That's my mother-in-law.
Your Honor, they have each been there at some time or another. Each has,
As
ma'am, each has interacted with Ms. Goebel. None of them has appeared in this court. We could make it a default judgment. If they want to ask for relief from judgment at some later point, we could discuss it. But each of them has been there, and I didn't want to be in a position where I had a judgment against Ms. Goebel and someone else claimed possession. And so that's why I named them as defendants. They certainly knew about it, and at least one of them had a conversation with Ms. King about it, but we named them as defendants. If you want to make it by default for everyone except Sarah Goebbels, that's fine. Just want possession. And in response to her question, which you answered fine, but I'll just add that if she moves, we don't get an order of eviction.
That's right.
So again, if I'm,
Here's what I'm going to do. They have not appeared. Okay. So it's going to have the same net effect, but I'm going to issue the judgment by default as to defendants 2, 3, 4.
Thank you.
And after a hearing, finding no tribal issue as to you. So if they, and I realize you might be sticking up for them, but if they want to do something about that, they'll have to file a motion with the court to get rid of it. Okay?
yeah, because we do plan on doing some, but that's afterwards.
All right. Very good. I've signed it. Thank you.
Thank you, sir. Have a good day.
You do the same. Lee versus Brevin. There's Mr. Fink. Where's Miss Rosen? Oh, there she is back there, hiding from me. Okay, hold on one moment. Was anybody able to find Miss
Bauer is in the outside conference room here, waiting for her case to be called in Judge Barr's courtroom. By Zoom.
Pardon? Can you do what? Who are you? I think she is representing you. And so what would you like me to do? Well, I'm looking at you, but you mean call your case?
Yes, sir.
You have an attorney.
Yes, but
It would be unethical for me. It would be unethical for me to call the case when I know you have an attorney. You know what? You can go out there and tell Miss Bauer, go out there, tell Miss Bauer that you fired her, then you come back in and you can represent yourself as soon as she lets me know. Court's going to stand in brief recess. I'll come out and deal with Ms. Rose and Mr. Ping. I will deal with you in a moment. You don't want to deal with me right this second. Court is stand in recess.
All rise.
Yep. Okay. Go. Hand me my screen box.
Now go free.
14A District Court for County of Michigan is now back in session. The Honorable.
All right. And court does call the case of Hamilton Crossing versus Tiffany Peters.
The plaintiff.
Jill Flowers and we, on behalf of Mich Peterson, who is present.
All right. I have before me an emergency order to stay.
Yes, Your Honor, and I'm asking, I don't know if we need it now that we're getting here. We're the other part of my motion was to set aside a default judgment.
Yes.
So I'm just gonna argue that.
Okay, that's fine.
Your Honor, Ms. Peterson did not appear for the hearing on April 12th because in between the complaint being filed on, I believe, March 12th and the date that the March 11th, I'm sorry, Your Honor, and the date that the default judgment was entered, she was offered a last chance letter by the landlord that they both signed on March 28th. So she thought the issue was resolved That's why she didn't appear, and I have a copy of that for your honor if you'd like to look at it.
Last chance agreement. I thought it was included. I know I read that.
Yes, I did attach it. to my
Good motion. Yes, I think I saw it. All right. Okay.
And, so that's why she did not appear, and then as far as,
That was on the 29th. Was that the day you actually signed it?
it appears to have been signed on the 28th of March.
March. Okay.
And your honor, additionally, Ms. Peterson does have significant mental health issues. And so, even though I think it's fairly reasonable for her to assume that she doesn't need to appear in court anymore on the victim case after this has been signed, I think she was also confused about if she did need, that was not clear to her.
Mr. King.
Your Honor, they signed the last chance agreement on the 28th. On the 29th, we had court and the case, and Ms. Peterson appeared, and the case was adjourned to the 12th for the purpose of setting out a COD with the court. And we prepared one, and by the way, the COD would have included a provision that she moved by May 1st, but she didn't sign the COD and she didn't come to court. And so she was told after she signed the last chance agreement, she needed to come back to court and that there would be a COD. And she didn't show up for court. And so we took a default judgment. 8 weeks later, this motion is filed, 56 days. And while my client is always willing to give a soft landing, and we can probably work something out on the writ date, there has not been good cause nor a meritorious defense to the case established that would require, or I won't say allow because I know better, but would prompt the court to set aside the default judgment.
And I have, the reason that I waited to file is because I monitored the court to see if a writ was filed, because Ms. Peterson, I connected her with SOS Relocation Services, and they've been just working on finding her a new place. But what happened is she and Grace at SOS thought that Ms. Peterson had a voucher for a 3-bedroom. And then when they got down to the end of the process, they found out that she only has a voucher for a 2-bedroom. So they had to start over. And then we had to get her voucher extended and all of that. So she is willing to move, but I just don't want there to be a time of the opposite of overlap where she and her 2 kids are unhoused, even though she, has a voucher and is willing to move. And I will say also that the incident that caused all of this to happen was in December. And in the interim, she's been court ordered to be medicated, and she is very, I've seen her when she's not medicated, and I've seen her when she is, and she's very different now that she's medicated, and she is able to make good decisions and such. So she hasn't, they did offer her a last chance letter, and she has complied with it. I don't know the purpose of offering this the day before a court hearing where they still want to evict her. And I don't know that she understood the inner workings of how all of that was going to fit together. And even if she understood it when she was here, I know that from working with her that she gets confused. And she missed, I'm sorry, one more thing. There was another court date that she missed around the same time as the second court date here. So I think she may have been having a difficult couple of days in tracking her responsibilities.
In the last I knew about that other court date, that was the criminal case for the event that caused her to receive the notice to quit. The last time I checked, and I'm not saying this is true now, but the last time I checked, she had failed to appear and there was a warrant out of 14-2.
Yeah.
And I brought that to her attention, and I believe that she called the court to clear the warrant.
Did you get that taken care of, ma'am, or?
Sure, I got another stuff going on in my house.
Okay, all right, listen.
I will contact every 3 days on the week. I take medication. I have 2 young boys that I have to tend to.
Okay, listen. Okay, hang on a second. When you leave here, go right next door to the public. Were you represented by the public defender's office at your court hearing? Do you know?
If the people did.
No, for
I
the,
didn't even know nothing about it.
Okay. Okay. Do this. You see anything?
At 14A2, she failed to appear for the arraignment retrial, so she's not yet represented.
Okay, she can still probably get help from them. So I'd ask you to stop next door out here. That's the public defender's office.
Okay.
Tell them I sent you there, that you got a warrant out of 14-2 in Ypsi. Okay. And that you need some help getting that clear. Okay. Because what I don't want to have happen is I understand you got a lot of stuff. I don't want you getting arrested on that. Okay. So you need you to do that. They're just right next to the this court. Okay. What I'm inclined to do on this case, counsel, do you think that a move out date can be worked out for your client? Where with the voucher process the way you have it now?
I just found out this morning that they extended her voucher to June 30th, which is really tight. What I was gonna ask Mr. Fink for was to just work with us as long as she diligently works with SOS to relocate, just let that process play out. But if she can't be out by July 1st, to not evict her. And I'm in contact with SOS on almost a daily basis.
So they've extended her to June
30th.
June 30th is her voucher. Oh, okay. So got it. Let me adjourn this out to the 16th of July.
Thank you, Your Honor.
Your Honor, is the order of eviction in the hands of the process server?
It is not. I did not sign.
July 3rd, is that what I heard?
July 16th,
July 16th.
2024. All right.
Yes, I'm available that day.
All right. Real good. So thank you, folks.
Thank you, Your Honor.
Thank you. Court calls the case of New Park Ridge versus Sakima Cooper.
Lou Maskill here for Ms. Cooper.
All right. This is your motion.
It is, Your Honor. We are here on my client's motion for summary disposition. If the court is ready, we can proceed with the argument.
Go ahead.
So it's our position that the notice that was provided to my client was vague and therefore didn't meet the statutory requirements and cannot be relied upon to confer subject matter jurisdiction to the court. Specifically under the HUD regulations, the state requirements found in MCL 600-5716, and even the lease itself requires that the termination notice must state the grounds for termination in enough detail for my client to prepare a defense. The notice itself merely says that there were physical threats and verbal abuse to property management staff. It doesn't cite the lease provisions that they're relying on. And as the court is aware,
But what's the requirement for the notice to state that?
what's the requirement for the notice to state?
The lease provisions or whatever. I mean, because statutorily, because of the physical threats, they could file a notice to quit.
Well, Your Honor, they have to plead with, or they have to, in the notice, put enough detail in there so that the client can prepare a defense. And that would include, who was involved with the incidents, when they took place, where they took place, what was alleged to have happened,
In the notice?
in the notice. There's a higher standard for notice pleadings in subsidized housing than compared to private housing.
Right, but did she take advantage of the meeting?
She did have a meeting.
Okay, was that laid out? And that was prior to the filing of the complaint?
That's correct, Your Honor.
And were the details regarding what was complained of the physical threats discussed in the meeting?
The threats, the physical threats didn't happen, so that's why.
Well, I'm not,
I mean, that's a question, but we
Well-
had the meeting, 5 days later. And
I think my client was certainly confused at the end of the meeting as to what was being alleged against her. And she, at the end of the meeting, also felt that, or was her impression that they were allowing her to stay, and was surprised by the fact that they had filed a case against her. By the end of the meeting, that was her impression that, you know, I think they said, well, if you get your ducks in a row, you can stay, something to that effect. She believed that she was going to be able to continue to live there. The other issue with the notice, Your Honor, is that they haven't specified in the lease, what lease provisions or what standard they're adhering to terminate the lease. So, if you refer to the lease, it says that they can only terminate in certain circumstances. One of those is material noncompliance with the lease. Another category would be good cause, and those are found in paragraph 22 of the lease. And good cause is also defined in several different ways in the lease. So they don't specify what exactly provision of the lease they're relying on, merely just saying that there were allegedly addressing. So it's our position really that they don't comply with federal or state laws about notice requirements in subsidized housing, or even the lease itself.
Your Honor, I just have three things to say. The first is that even if what my sister at the bar alleged was accurate in terms of facts, that would not deny this court subject matter jurisdiction. That's the sole basis for this motion, 0.116C4, that you lack subject matter jurisdiction. We have litigated this issue before, albeit in a CARES Act case, but it's the same thing. We filed a complaint with a notice to quit and a copy of the lease pursuant to the statute. You have subject matter jurisdiction over summary proceedings. That's the first part. Secondly, the complaint itself alleges a violation of lease paragraph 12 and 22 and references the notice to quit. And third, if the defendant would like a more definite statement, you can order us to provide one and we will lay it out. Those are my three responses, Judge. I don't think I have anything else to say.
Anything else?
Yes, Your Honor, with regard to Mr. Fink's last point first, the reason that the notice itself has to include more specific details is it provides the tenants with an opportunity to decide how they want to proceed. Specifically, she may have decided to move out. She may have decided to, seek other arrangements. It's not appropriate to leave that all until a trial to take place before she can learn what the actual accusations are against her.
Well, but isn't that the reason really for the meeting?
It's the law requires it to be in writing, Your Honor. The meeting is a chance to discuss the terms, but she didn't even know what she was walking in to discuss when she came into the meeting, really, because it wasn't spelled out for her. The second issue I want to address, Your Honor, is the subject matter jurisdiction. Ypsilanti Housing Commission versus O'Day specifically states that if the notice itself doesn't comply with statutory requirements, that it's invalid. And then you couple that with Park Forest, and which says that you need a proper termination notice in order to have jurisdiction or hear a case. So those two cases together, the notice is improper. You don't have a proper notice. You don't have subject matter jurisdiction to hear the case. That's our position on the subject matter issue.
You're saying in O'Day it said what? I mean, I remember O'Day because I litigated it, but go ahead.
They found that there wasn't a proper notice in that case and that they were required to adhere to.
But the reason for the notice being improper was?
I mean, in that case, in that case, there was the 7-day versus the 30-day notice, right? And so they gave a 7-day notice, which I think was provided for in their lease, which didn't comply with the.
Which didn't comply with the state statute regarding, but complied with HUD regulations.
Right, which therefore.
Which then taught everybody to comply with state statutes and not HUD regulations, which this notice in this case complies with the state regulations.
I don't think I disagree, Your Honor, that it complies with the state or with the lease. So even if you find that it complies with the HUD regulations, I would say it still doesn't meet.
I mean, if the basis upon which you're saying that this court doesn't get jurisdiction and that the notice for that reason is improper, I think that the notice is proper. If the notice has to state certain things, it does that. To the extent that there is some, I guess, penalty or something that might adhere to or near to your client regarding this, I don't think that happens in this case. I mean, the 10 days to discuss it with management, she had those 10 days. I don't know what came out of the meeting. I typically don't know what comes out of the meeting, but they typically do that before such time as they do it. But as far as the particular provisions of the state and the conferring of jurisdiction on this court, I believe that the notice is satisfactory in terms of complying or conferring upon this court notice. I just will say one thing. It's April 1st. So I'm going to deny your motion for summary disposition on those grounds. Now that there's a case before me, I guess I am a bit concerned as to at least what your client has indicated, that she's not sure of what the allegations are. And that there may have been, after this meeting, at least her impression that she may have been able to stay. And I don't know. Does she not know what the allegations are based after the meeting? Whether she agrees with them or not. Because one of the things that she said was, it didn't happen. Okay, well, that may have to be litigated as to whether or not it happened or not. But
Your Honor, I don't know what the allegations are, so I haven't been able to go over that with my client to answer your question.
Right. Okay.
Your Honor, what if we did a final settlement conference? That we give all of us a chance to be at the same place at the same time. And in the meantime, I will get as much information as I can and forward it to Ms. Maskell.
Well, I think, I don't have a problem structurally with that, but I think there needs to be something more definite so that counsel can sit down with her client. It used to be at those meetings that there was something written that came out of it. I don't know that was ever required, but I certainly
I think there was something, but I was focused on this motion and the one reason for it. But are you ordering us to provide a more definite statement?
Yes. So I would probably move it into the latter part of July.
Like the 22nd?
23rd. Why do you keep picking
23rd.
dates? The 23rd. That's a Tuesday.
We'll work it
Counsel
out.
has been willing generally to comply with any discovery request.
Generally?
But potentially and very likely there will be some discovery that's necessary after we get that 28th document. So that's my only
Right. And
thought about timing.
And here's what I also want to know. Is there a police report? Is there any outside agency that would have responded to any of this?
Not that we're aware of, Your Honor.
Mr. Fink?
I do not know.
Got it. Okay, that's fair. Okay,
We're good. Thank you, Your Honor.
all righty, thank you. Court recalls the case of Samanek versus Ackerman and Meltzer.
Money have you spent on the repainting?
Over $1,700 for paint and labor, and it's not done.
Who's doing the painting?
man named Rob Reese and his wife Sherry Reese.
Is there a bill?
I have an estimate for $1,700, and that's what it is. It's an estimate. I have another estimate.
Where's the estimate?
Sorry.
Do you have that estimate with you here?
What provision is plaintiff relying on regarding the painting?
In the complaint
No, in the lease.
or damage to the premise?
Sir, was it going to be painted anyway? I mean, after they moved out, wouldn't you repaint before you rented?
Not necessarily. They were here. Year and 3 months. So.
Was there difficulty in repainting because of the dark colors?
Yes, it required 3 coats over the.
Did you do the painting?
I did not do it myself.
Well, how is he going to testify to that, counsel?
Were you present to see what was going on?
I was there every day that they were there. I watched what they were doing. Physically not able to do all that work.
Right, I get that, but are the painters going to be here testify?
No, Your Honor.
Because all of this is hearsay.
Well, he can testify as the amount of money he's paying to have something done.
Maybe, but he's also saying he's got a contract and the necessity of it being done. They have a right to challenge. I don't have the painters here. I mean, they're the ones telling him that's what needs to be done. Or am I missing something?
He's relying upon his knowledge of what paint looks good and what paint doesn't look good and how he can solve the
I
problem.
don't even know what that means. Somebody is coming in and doing the work. He's talking about what they're doing and the necessity to do that. That's all hearsay, unless I have them here because they're the ones doing it.
I believe, okay, we'll move on then.
Go ahead.
Did Travis ever tell you there was any problems with that house? Any repairs needed to be made?
Yes.
What did he tell you and when?
Specifically the bathtub.
What sort of bathtub?
Old cast iron bathtub that appears to have been paint job put on it years ago, and parts of it were chipping off near the drain.
And what did Travis say about the bathtub?
Wanted to do something about it, and along the edge of the bathtub on the shower enclosure, there's a part that's coming apart. And I do not remember that happening. I did not remember seeing it prior to that. Travis pointed that out also. And, it was not able to.
Did the epoxy paint that was peeling on the bottom of that bathtub affect the bathtub use at all?
I don't think so.
Was there also other bathing facilities in that house?
The new bathroom was put in approximately a year before they moved in. There was ceramic tile shower and toilet and sink. So there was another place to take a shower.
Do some of your pictures show those,
Yes,
the bathtub and the other ceramic shower?
yes,
And you took these pictures?
yes,
And these are exhibits 10, 11, 12, 13, 14, 15, and 16. Is that correct?
yes. Some of them are the bathrooms, some is the yard, the driveway.
I show you 2 pictures there. I believe that's exhibit 19 and 13. What do they show?
Number 13 shows the old bathtub and shows the inside around the drain. Number 19 shows the new ceramic tile shower and the new bathroom.
Picture 16?
15 shows a surround around the shower in the old bathtub where it's become a little unattached from the wall.
I would move for the exhibit of 13, 14, and 16, my approach to them.
Any objection?
Did they ever tell you about any other repairs that need to be done to that house?
Not that I can remember.
When they moved in, was there any discussion about the house and the barns and the farmland surrounding that house?
Yes, I told them that I have a farmer that farms the land. He will be going through the driveway, coming in and out. They have irrigation on that farm, and especially in the summer months, he would be in there pretty frequently. My son has and had equipment stored in some of the buildings. And another neighbor has hay stored in some of the buildings, and I have tractors stored in some of the buildings. And I told Travis that what he has is the use of the house and the detached garage, not the other.
These exhibits here in front of you are listed as exhibits 10, 11, 12, and 15. What do they show?
Shows the farm property, shows the driveways, shows the buildings. Shows shows where my farmers have to come through the driveway there in between the house and the buildings to get to the back of the farm. And the driveway that goes from the main driveway up to the garage is a relatively short driveway.
Did Travis ever complain about anybody going in the driveway?
Yes.
What did he say?
Well, he felt that it was a private driveway for him only. Like he didn't understand that it was a farm driveway. My son actually has been in and out of there several times. My farmers that farm the land have been in and out several times. The man that puts hay in the barn and got to the point where Travis insisted on having call ahead notice, make an appointment to come through the driveway. So trying to cooperate and keep peace in the neighborhood, we would call up as often as we could. We just didn't try and keep peace.
I would move for the admission then of these exhibits, Your Honor. The defendant has copies of them.
Any objection?
No objection.
Those are admitted.
Yes. Did Travis ever give you a forwarding address to where he was moving?
Not right.
Okay, did he ever give you a forwarding address?
I assumed he moved in with his mother and stepfather.
Not the question. Did he give you a forwarding address?
No.
Go ahead, Ken.
So in summary then, what money is owed to you?
Month's rent.
Of $1,200 per month.
What months are those for?
March and April. $293.66 for the electric bill. $1,889.02 for the program.
I'm gonna go back to a question that I had that I didn't get an answer to. What lease provision is he relying upon regarding the painting? Is that the one that plaintiff's relying upon, counsel? Paragraph 7.
We're talking about paragraph 7 of the lease, which provides.
That's about improvements and alterations to the premises.
Yes.
Normally that's applicable to fixtures. What provides that to plain? I don't. Well, I'll let you make your argument at some point as to how that's applicable to painting, but go ahead.
Yeah, I have no further questions to this witness.
Either you have questions of this witness.
I let to approach right here. I'm sorry, I've never done this before.
Right
So. Mr. Samanek, are you familiar with section 9 of the lease agreement that we both signed, access to premises? So can you tell me exactly who within, you mentioned that there were multiple parties coming in and out of the private drive. What part of that is within section 9 as being agreed upon?
First of all, it's not a private drive.
Okay, so beside the point, access to premises. It says landlords or their agents shall have free access within reasonable hours to the leased premises for the purpose of examining or exhibiting the premises to prospective buyers or tenants, or for making alterations or repairs. Is there any language that states exactly what you had just specified about farmers coming in with equipment?
Says the landlord has free access.
To make,
The landlord.
repairs, alterations, or to show prospective buyers. Were you doing any of that? Were they doing any of that?
For every document.
Hold on, you got one question, let him in.
Yes, Your Honor. Yes, Your Honor. For-
My other tenants should have free access also to that main driveway.
So was that written into our lease agreement? That for our awareness?
No, I'm sure you were told about it.
Okay.
You were told that the farmer would be coming through there,
So-
especially in the summertime.
In reference to the lease agreement, what we signed, can you tell me all of the evidence that's been shared about the access to the property? If any of those are within violation or accordance of the lease
I think
agreement?
what you're asking is, those individuals that are coming on and having access to the premises, do they fall within the parameters of paragraph 9? I think that's what you're asking.
That is what we're asking, Your Honor.
I believe they do.
Okay.
How do they do that, sir?
Pardon me?
How does, in your own words, how do their access to the premises fall within paragraph 9?
Okay, first, okay. Access to the premises means the farm. The farm, this rental house is only one piece of the farm. The farmland is a piece, and there's several outbuildings there that are other pieces of the farm. So my people that rent the land from me and rent the barns from me have access through that main driveway. They do not have access to his house or that short driveway that goes from the main driveway to his house. That's the only part that's private for them, is that short driveway, about 50 foot long, from the main driveway up to this one-car garage. That's the part that Travis did not seem to understand.
Well, hold on. So what's the address there?
Address of the house,
Yeah,
15867, is that correct?
okay.
Your address.
So go to paragraph 1 of that lease. What did they rent according to the lease?
The house,
No, look at the lease. I get your interpretation, and you may have an interpretation of what they rented, but what did they rent according to paragraph 1?
says the premises known as 15867 Austin Road.
That includes that driveway, right?
Do the barns have a different address, Mr. Stanley?
Oh, ma'am, hold on. That includes that driveway, right?
If they have access to that driveway to the house, yes.
Okay, but that's the lease premises.
Barns are also part of the farm.
Well, that may be your other problem. Because under terms of paragraph 1, they leased that entire premises. Didn't they?
The understanding was at the time when we talked about it, is they lease the house and attached garage, that's it.
Paragraph 1, I understand what you're saying is the understanding. But paragraph 1 says precisely that they are renting the lease premises at 1587 or 867 Austin Road, right? Does anywhere in there say anything about the lease premises or about the house? Or let me put it another way. Does anything in the leasing agreement exclude anything on that property?
Doesn't specifically exclude it, it doesn't specifically include.
No. That can be your interpretation of it, sir. You'll answer my question because the lease premises is that address, right? It doesn't exclude anything on that property. So it doesn't say, for example, that address with the exception of the barn. It doesn't say that, does it?
Doesn't say it accepts it.
Is there any other writing that excludes any, that's signed by both parties, that excludes any part of that property? Go on to your next question.
Your Honor, may I submit some evidence for the painting?
Okay, what do you have?
We have a listing that they had made to rent the house out, and all of the photos show the existing paint, showing that no painting has been done as of March,
It was-
May 23rd.
Yeah, the last update was May 23rd.
With no update of photos,
In the same.
but it
time.
shows the existing photo, the existing paint in the exhibits that they submitted to you.
Have you seen that, counsel?
No, I haven't. Today she has pictures, but
You have a copy. Let's provide it to you in another folder.
Do you have them?
Yes, he
Well,
does.
Do you have any objection to those photos?
I would object to, Your Honor, in that is something off the internet in May. And I think if they're supposed to be cross-examining this witness, why don't we ask him when they started the painting? Who put that on the internet?
His associate Melissa.
Well, hold on a moment. Hold on. Counsel, I gave you great leeway in terms of your questions that elicited hearsay. And now you want me to do that with them.
I guess we can accept.
Because, hold it. Because, counsel, if you want to play it that way, we can play it that way. Because here's the deal. Anything regarding that painting, they don't need to provide anything to me. Because all of that is hearsay. The bill is hearsay. All of that's hearsay, because I don't have anybody here. So if that's the way we want to do it, I'll strike all of that. I'll deny that being admitted. How do you want to do this, counsel?
You can have their pictures admitted as evidence, Your Honor. And
That's what I thought. How many pictures do you have?
17.
That's 17?
We're just
Okay, so that's fine. That's fine.
16, 17, 18, Your Honor.
You have 18 pictures.
Yes, sir.
They're all from one source.
Yes, sir.
And they're all the inside of the house.
Correct.
All right, so here's what we're gonna do. We're gonna mark that all as one exhibit A, plain or defense exhibit A. Do you have questions regarding that too?
I have no questions for that. Just wanted to state that it has not been done.
Got it. Well, let me follow up with that line of questioning. Sir, has the painting has not been completed? Has it been started?
Yes,
When did it start?
I don't have the exact date, about 2 weeks, 3 weeks ago.
So is the house currently being rented?
Your Honor, can I ask a question?
In a moment. Did you have any other questions of this witness?
Yes, sir.
Pardon?
Yes.
Go ahead.
I would also like to touch on the section 5 of the lease with paying the utilities. Mr. Samanak, it says that we must pay the propane no later than the 31st of December of the year the propane was purchased. Mr. Samanak, when did we move into this premises?
I don't know the exact date. You signed it on the 27th of December.
So it says that our lease agreement starts January 1st of 2023. And when was the first propane purchase for that house that you're claiming?
Propane that was in the tanks when you moved there.
Mhm.
Purchased in the summer of 22.
Okay, so according to section 5, where in that language does that state that we owe that propane if we did not move into the 2023? Within the lease,
Well,
what does
hold
that
on.
state?
Hold on. Her question is, where in that provision, sir, does it say that?
The only place it talks about propane is in section 5.
Okay, so the question then is, where does it state that they would be liable for what is in the tank before then?
Doesn't say it in the lease, it's what they agreed to before they signed the lease.
Go ahead, ma'am. Well, hold on before you go. Sir, if you look at paragraph 5, right? The only propane that they would need to pay would be that which was purchased in the summer of 2023. Isn't that correct? That was a question.
I do agree to.
Sir, listen closely to my question. When I'm looking at paragraph 5, that paragraph basically says the only propane they need to pay for is the propane that would have been purchased in the summer of 2023. Isn't that what that says? Go on to your next question.
And Mr. Samanak, I wanted to reference the conversation we had in January regarding the reduction of rent. Was the stipulation not that we were going to read the meters and then pay the propane appropriately once we moved out on May 1st?
I don't remember you saying that you would pay them.
We agreed that we would read the propane meters and that we would figure out how much that we owed at the end of our lease. And were we given that opportunity?
Remember that conversation, although we did talk about reading the meters when you moved out
Mhm.
and giving you credit for what was in the tanks.
Okay, and so with that being said, they paid up until February when we asked to have the readers met, and then we read, and then we'll pay you appropriately, because we did not know the amount that we owed. It was not clear due to all the handwritten letters we've gotten.
Got a question? Do a question. I don't need a statement.
Okay. How would we know what we owed if we had not read the meters yet?
At that point, you owned almost 100% of the bill, so there's a lot of it could have been paid.
According to section 5, we did not owe 100% of the bill. So how would we know how much we owed until we read the meters at the end of our lease?
You had to go by the numbers I gave you.
Mm-hmm. Correct.
And do you have a date when you would have given us those specific numbers? I know you referenced that there was a document. We don't have a document. So could you provide us with a date in January you would have done that?
I believe I gave you a copy of the bill. The propane was delivered in the summer of 23.
And then we made, obviously have made a $1,400 payment towards that, which you've admitted. So we have been paying on that. So when have we defaulted on paying the propane?
Right now the bill's not paid yet.
Okay, we're in court. So,
Again,
You
of
gave
course.
us that for a month and a half, 2 months, and you haven't paid a nickel cent.
But when did somebody give them a number?
When we made it.
I mean, outside of being here, when did they have a number?
Gave them a number.
we were served with court documents before we even moved out, stating that we owed that much money.
You gave them a number when they moved out.
Shortly after.
Where is the writing where you gave them the number they needed to pay?
It was in the original complaint.
Ma'am, not the it wasn't directed at the defendant. When did you give them a number?
I have the exact date in front of me.
Did you give them a number in writing?
Probably at our first court hearing. After a very heated one-way conversation with Travis, he said he'll never pay another dime.
Okay.
Mr. Salmon, can I ask what time frame that conversation took place in? Was that the call we had in April after we had already satisfied all payments made to you?
Sorry, I didn't get all that.
So can you reference the time frame that call was made in? Was it in April after we had already made all prorated rent and satisfied propane payments to you?
Hold on, folks. What was the propane bill that was paid in, that you purchased in 2023?
Copy of it in the paperwork, there was approximately $1,700.
Okay. And they paid $1,500, right? Or their parents paid
$1,400.
$1,500.
1,400, sir.
14. Right?
Mom and dad paid $1,400.
Okay. So at most, then when I'm looking at the language of this contract, by December of 2023, they owe $300.
$1,400, paid $500 in December, $500 in January.
I don't care when it was paid. Here's the problem that I'm having. The lease itself indicates that the only propane that they need to pay for is that which is purchased that year. So the $1,700 purchase in 2023 needed to be paid by, according to this, by December of 2023, they needed to pay whatever that bill was. Right? Whatever this is the other problem with the agreement, because I'm not sure, according to the lease, that they would be required, well, a couple of things. The propane that was purchased in 2024, right, that they used.
There was no propane purchased in 24. It was all in the summer of 23 and the summer of 22.
Okay, so all they owe then for propane is $300.
But we did not use all that was in those tanks, Your Honor. There's still 900 gallons left.
Well, yeah, that's a whole other issue. Okay, go ahead with your questions.
In January, when we had our phone call, me reaching out about prorating the rent due to the continued violations of the lease agreement that you had not acknowledged multiple times in our previous calls. Did I come to you on the basis of the violation of the lease agreement in reference to wanting to prorate the rent? Was that, I mean, can you confirm that that was the nature of our conversation?
Conversation one-sided, Drew screaming for about 15 minutes. That's so I decided to let you go ahead and move out.
Do you have evidence, what you just said, of me calling you every name in the book?
My wife heard it all. You slandered her, my wife, my kids, everybody involved in my family. You made bad remarks about us.
Okay, beside the point, the question that I ask you is, reaching out to you, was that not on the basis of the repetitive, egregious violations of the lease agreement that you had acknowledged but not taken any action on?
You violated more provisions of the lease. Only thing I've done is I did not get that bathtub taken care of. I was unable to get it done. It's the only thing that I've done.
Mr. Samanak, in regards to that question, do you not recall the videos and photos we sent you of all the pest infestations?
I never got a video. My phone does not receive them. If you send them on the phone, I did not get them.
Do you receive photos?
No.
No?
No.
Okay. Was that ever communicated to us? Okay, for sure.
Go ahead.
I have no further questions.
No further questions, Your Honor.
All right, you may have a seat.
I have no further questions at this point.
Sir? Is the house been listed?
No. It was put on Zillow for a few days by mistake. I was not.
By mistake?
Yes.
How did
The lady that put it on was going to help me, and she misunderstood what I told her. And
she was going to help you do what?
Try and list the house for rent. And there was too many things that I needed to do, and I told her that I don't want to do it. She said, well, it's already on, so we'll take it off. She did.
When was that?
Sorry?
When was that?
Don't have the exact date, but probably a week or two after they moved out. Moved out the 1st of May.
Do you have any pictures of the current status of the painting?
I can tell you the 3 rooms that were.
Do you have a receipt for the purchase of any materials regarding the paint?
Spent approximately $300 at Menards.
I'm gonna go back over these figures you're indicating your own. You're saying that they owe you $1,200 for May and April,
Each, yes.
total of 20 March and April, $2,400.
Yep.
How much are you claiming for propane?
1,800.
1859 or 1889?
Yes.
And then 293.66 for electric. Those are all your claims.
Well, the paint.
And the painting is how much? 17, how much?
I don't have the exact amount, but the labor is going to be 17 or more.
What do you mean you don't have the exact amount?
They've already used up about 1,700.
Do you have a canceled check, anything that tells me that that's what you paid for painting?
No,
Pardon?
I do not have an answer.
How'd you pay them?
Give them credit. It's the only money.
Dear goodness. So the person doing the painting owes you money.
Yes.
And so they're supposedly doing this work and then you're going to take it off of their bill.
Yes.
So there's been no outlay of any monies from you to a person to paint these premises.
Yeah.
And I don't have a bill for paint. I don't have a bill for any of that, right?
Get an estimate for the labor.
Whatever that is, I don't know who created that estimate.
I have a second estimate that's higher than that.
I don't know who it's okay. It's not the way this works. You're telling me that it's 1,700 for that. But you haven't paid that.
Yeah.
Well, that's not my question. You have not paid that, correct? You're saying that you bought supplies at Menards, but I don't have a receipt for that, right? So in reality, I have nothing here today that tells me anything about the painting other than what you said, right? And so off of all of this figure, you do admit that there's a $1,200 security deposit.
Yes.
Any questions based upon the court's questions?
I have nothing really.
No.
You may step in. Any additional witnesses for the plaintiff?
We have no further witnesses at this time.
Yes.
All right, before I hear from the defendants, and I don't know if I'm necessarily going to need to hear from the defendants unless for whatever reason plaintiff wanted them called, because folks, now I don't mind coming back and making the ruling, but I think the parties should try to figure out if they can resolve this without screaming and yelling at each other, and I'll give that opportunity because there's some agreement to pay half the rent. One party's claiming it's because of stuff that wasn't done on the premises. The other saying it was contingent upon this propane bill, which I'm not sure that propane bill is owed. Outside of that, whoever drafted this lease, and this lease, counsel, as I'm sure you're aware, any ambiguity in that lease is going to be construed as against your client. And so I think you need to look at that language very closely because it's his lease.
I understand.
And so there's that part of it. The other, and those ambiguities, just so that the parties are clear, are the premises that's leased and interference with that premises, because it got a problem in that initial paragraph.
But there's no part of that lease refers to anything in the way of quiet enjoyment and use of the premise.
except by operation of law.
I understand.
I mean, even if it's not in there. Okay, well. So I'm going to tell you what, I'm going to try to handle some of these other cases. You guys, if you guys can talk to each other civilly, need to go out and resolve it. There's 1,200 sitting in a security deposit. I have a paint job that I'm not even sure is done or is going to be done that isn't going to be paid, that somehow or another is on some credit. I've got property that they lease, which by the leasing agreement itself says they lease that whole thing. And then, goodness help us all, we have paragraph 5, which is the most confusing provision regarding the payment of propane. And if you guys want me to give you my decision on that, I'll be more than happy to. But I think you guys probably should see which way the wind is blowing, go out there and try to negotiate something. If not, you'll get my call on it. I'll break on this case. All right.
I'll get my stuff out of Mr. Ellis's way.
All right. Were the parties able to try to talk at all, or do you guys just didn't?
Unfortunately, we cannot resolve the case, Your Honor.
Okay. All right. I think I understand defendant's position unless you guys wanted to testify about something. I don't think I need it necessarily to come to my decision. All right. Closing arguments.
Your Honor, we have a lease agreement here that it seems as if both parties are having difficulties in interpreting that lease. But the lease is clear that changes have to be in writing. We feel that the testimony has been sufficient for the court to award a judgment for the unpaid propane. We believe the unpaid amount is $1,882, unpaid electric of $293, rent for 2 months, March and April, of $2,400. And then we have the issue of the paint. If the court wants to disregard giving the plant any money for repainting, as long as we got the propane money and the back rent and the electric utilities, we would be satisfied. There's no provision in the lease that says they're going to have quiet enjoyment or exclusive use of this premise. There's been no testimony given to the court as to why they should not pay the 2 months worth of rent. There was testimony that Mr. Samanak at one time said if they paid the propane, he would reduce the rent. The propane bill has not been paid. Even if you interpret the lease as saying that they only have to pay the propane bill on December 31st for propane that was delivered that year, there is still an unpaid balance of propane owing. So I would ask for a judgment for the expenses as we stated there. And then you could give them credit for their $1,200 in a security deposit.
Closing argument.
Your Honor, we do not feel as if we owe the propane due to the prorated rate of over 900 gallons still being in the tanks. With the $1,400 payment due, which would null and void his claim of the rent, which we have satisfied per our agreement in January. And we dispute the charges as well.
Your Honor, the entire basis for this was reaching out to the plaintiff in January due to multiple egregious violations of the lease agreement. The plaintiff has been unwilling to, and his attorney, to review the evidence, the severity of what's occurred and why we had reached out in the first place in January to prorate the rent and facilitate an exit of the lease. In this case, we do not feel that we satisfied the rental payments in accordance with what we agreed to in January. That rental, prorated rental payment was not predicated on propane payment in any way, shape, or form. Multiple parties were present for that call, and I would say that all of them can attest to the fact that nothing of that nature was said, nor did I personally agree as a party on the call to those terms, those verbal terms. So we do feel that we have satisfied not only the rent, but the propane requirements as well. We do feel that there is unaddressed matters with the violation of the lease agreement and why we had initiated all of this in the first place, but recognize that there's a time and a place to address those matters as well.
And we move for our deposit to be paid back to us in full.
Court has listened to the testimony and read the pleadings, and frankly, the defendant's position is rather straightforward. They acknowledge that they owe the 293, I think it was 293.66, which are the utilities. So that's the easy one. The next rather easy one, well, in the court's going to make its own finding on this, and that is that what both parties agree on is that for those 2 months, there was an agreement for basically a 50% rent reduction. One party says it's because of what were the conditions of the premises and regarding use of the premises, that being the defendant. And the plaintiff is indicating that the reduction came because of, or if the reduction would take place and the defendants were to pay the propane, but had somehow not done that. And so therefore he considered, as his words are, he considered the agreement void. I have to say, when the court analyzes that, the plaintiff's position makes no sense. I don't know why I would give a reduction in rent for somebody to pay me another bill or outlay in cash. That just doesn't make any sense. What I think is that there was some dispute between the parties, and the court would find that was more along the lines of what the defendant is claiming. And I find that their statement regarding that is correct. I don't believe that this propane was of such an issue that it would require the rent to go down. If one's not paying what in effect may be a utility, why would I reduce their rent so that they could pay me that? Again, that makes no sense to me. And so the court believes that for those 2 months that the defendants do owe $600 per month, but the $1,200 for those 2 months. I would indicate that and I'll put it this way. My other reason for finding that regarding the reduction in rent is the same confusion that comes from the lease itself. The lease itself, and this is why people should probably have attorneys draft leases for them in full and fully understand its implications, because that leases that whole premises. That whole address is leased. There. So there's that. So the court does believe that they owe that $1,200. Yes, ma'am.
Sorry, we did fulfill that in February when we paid January, February, March, and April to Mr. Salmonak.
So you paid the $1,200?
We paid $2,400 to him for those 4 months and the 50% reduction.
Got it. Okay.
So we've already satisfied.
You already paid that. Got it.
His son-in-law, Harvey Proctor, came to.
I don't need to know all of that.
Sorry.
She answered my question. Are you two married yet?
3 months.
3 months you get married? So by that time, you're going to learn to keep your mouth shut after she speaks?
I'm getting.
I hope so. All right. Maybe you'll get it. All right. So that I want to make sure I'm clear, does plaintiff agree that that $600 was paid?
Well, Your Honor.
I'm not looking for full argument. I'm just saying, did they pay the rate at $600 for those months?
But for those 2 months, but if you look back at January, you know, $600 from January forward.
I'll take that as a yes. I'm done. So I don't really need to do anything with that because I think that they fulfilled the 600. The plaintiff himself stated that whatever that agreement was, he just said they didn't fulfill and then unilaterally decided that they had breached the agreement. And so now is going to charge them. It can't work that way. And it won't work that way. And the court's not going to enforce that to happen. Particularly when now he's here attempting to try to sue for the propane that he wanted them to pay, which some of that, quite frankly, given the lease, they don't owe. Now comes the really, in this case, well, let me just deal with one other issue. So I've dealt with the rent. Quite frankly, I believe that the defendants have satisfied the rental provision as outlined and as amended by the parties. As to the electric, they admit that they owe the electric, just so that we're all clear. In regard to the painting, I'm going to say this, and I'm going to try to put it as gently as I can. I have some issues regarding credibility from the plaintiff's side. And the issue that I have regarding that credibility is that it was very clear that the court was led to believe that there had been some outlay of cash, and I will have my recorder go back, about payments that he made in the amount of $1,700. Not true. I don't have a receipt here from Menards. I don't know if that's paid, but I certainly have questions about the plaintiff's credibility to this court. It wasn't until later that it turns out there was no payment in part on this paint job, that it was credit because that person owed him. That's a whole different scenario than to say, I have paid this money. And I think it was quite honestly a direct attempt to mislead this court as to what was actually transpiring. And so I don't believe that plaintiffs owe anything for any painting. When I look at that provision, one of the ways to interpret that provision regarding alterations and decorations, and because of the last portion that everything then belongs to the landlord. If it were a decoration, decorations don't belong to the landlord typically. They belong, unless, well, until such time as they become a fixture to the premises, that's when they become the landlord's property. Otherwise, they could be removed by the tenant. So theoretically, under that provision, had they hung a painting in the place, it all of a sudden belongs to the landlord. I don't think that that's the intent. I also don't know what occurred with this painting, but it doesn't really matter to me. I think, quite frankly, that the plaintiff lied to the court, or at least misled the court or tried to mislead the court as to what he paid. And I'm having no part of that, and I'm not going to award any of the $1,700, anything for the painting in that regard. With regard to the propane amount, which is, and again, this is why people should have leasing agreements at least looked over by attorneys regarding this. At least once a year, presumably, there is this purchase of propane. Now, I mean, it's rather clear. Propane shall be purchased by the landlords once per year and shall be reimbursed by the tenants as soon as possible each year, but not later than the 31st of December of the year propane is purchased. So I can understand what plaintiff intends to do or is trying to do with reference to that propane, but he's stuck with his lease. He's stuck with his document. He's negotiating parts. I mean, it's a very strange thing because according to the language here, I mean, I understand they measured it at the beginning. There's supposed to be this other credit at the end, whatever. The only thing by the terms of this lease, the only amount that the defendants would have to pay would be the amount paid in 2023. And they owe that. We can talk about credits, we can talk about whatever. None of that matters realistically, right? And the reason why this is a bad way to do it is because the next tenant is really the one that benefits from what you've done. That's part of the problem. But that next tenant also could have had a deficit to what you've done. The fact is you guys didn't use enough propane to make it even for you. That's really what happened. And maybe that's the risk in having this type of an agreement. I don't know if that was the intent of the parties. I'm just taking the plain language of what's there. That propane bill. So what they owe is just the propane and only the propane purchased during 2023. And that is an amount of $1,737.34. They paid $1,400 of that. So the net effect of that is, I got my math correct here, is that there is $337.34 owed. Whether you left propane in, what you had in, not part of what I'm looking at here in this case. So they owe the plaintiff that amount. Plus, Emily, you're going to have to help me with my math here. The plaintiff owes, or the defendants owe to the plaintiff $631 in utilities and propane. They have a security deposit. While I thought maybe there might be an issue with the doubling of the security deposit, they haven't complied with the part of the Landlord-Tenant Relationship Act regarding the security deposit in terms of the notification, the written notification, which can occur in different ways now, but the written notification of forwarding address. They may have known where, they may have known any of that, but I don't think that's been done, and neither do I think it's properly been pled, although it becomes an issue in the case. But so the net effect of all of this, after hearing all of the testimony, is that defendants owe plaintiff $631. There's a security deposit of $1,200. The court's going to order that I won't put it in the form of a judgment. I'll put it in the form of an order that if not paid within what would be 15 days, that it would then become a judgment, which the defendants could enforce, that the plaintiff must pay to the defendants $569. That's the judgment of the court. Counsel for the plaintiff will prepare for order.
Okay, Your Honor, just so I'm clear on this now, there's also the cost of $190.
You have to prevail on your claim.
Pardon me?
I'm not going to award costs. I don't think you prevailed.
Well, we have the filing fee, and we have the service fee and the motion fee.
How much do you want the cost, counsel?
Okay. So you're saying we're not entitled to the.
I am not awarding costs, but what do you have as the total amount of the cost?
We have,
because quite frankly, I think, counsel, this matter should have been resolved between the parties somehow and or another, and has been an absolute waste of time.
Your Honor,
for all parties.
I practiced law for 49 and a half years, and I've settled every case that could be settled. These people thought they were owed.
I don't care why. because I now rendered my decision, counsel. I'm just letting you know. I think it was a waste. I just think it could have been resolved somehow. How much are your costs, counsel?
The costs are $190 for a service fee, motion fee, and filing fee.
Parties will split that cost in the case. You take $100 off of whatever I said is owed, and then we're done. So it'll be $469 coming. I'm done, folks.
Can I ask one question? I'm so sorry.
Probably not, but go ahead.
I just want to know, are we paying him anything or is he paying us? Or
He's got to pay you $469. If he doesn't pay it within 15 days, it will be transformed into a judgment that you can enforce.
Okay.
So that nobody has to. Thank you.
Good.
Are you kidding me?
Oh my God.
You have got to be kidding me. What is going on today? This is a joke. This is a joke. Today is an absolute joke. We need an interpreter.
I need an interpreter when I cannot express myself sometimes.
Joke. Oh my God, sir, put that cigarette out. I don't give a crap that you are outside of this. What is wrong with everybody today? You know what, Miss Reed? We're gonna start bringing people in person. People gonna learn how to act in a courtroom.
Can you hear it? Can you hear it? Ma'am? Ma'am? Can you hear it?
No.
Okay.
I have no patience for that. And trust me, out of the day, I'm sitting up here, I'm the one that needs a drink.